you decide to get behind the wheel because you're doing whatever and then end up killing somebody. That's not going to happen.
What you just heard is the core tension of this entire hearing. Judge Simpson is setting the tone right from the beginning, and it's a tone you hear often in serious probation and substance-related cases, public safety above everything else. This courtroom moment immediately tells us the stakes here are not just technical violations or paperwork mistakes. The court is concerned about real-world consequences. When a judge mentions the possibility of someone getting behind the wheel and killing somebody, that's not hypothetical courtroom drama. That's the legal system reminding everyone that probation violations can escalate into tragedies. Now let's break down what's actually happening in this hearing. We have multiple cases being addressed at once, which is already a complicated situation. Why imports bat buano arcane? There are 2 sentencing matters and 2 probation violation matters, meaning the court is evaluating past crimes while also determining whether the defendant followed the rules after being given a chance outside of jail. And that second part, probation compliance, is often where defendants run into serious trouble. Throughout this hearing, you'll hear defense arguments, probation officers laying out compliance records, and the defendant himself trying to explain his situation. But the big question looming over everything is simple. Did Mr. Stringer take advantage of the opportunity probation gave him, or did he waste it?
Defender Natalie, Mr. Stringer, who stands to my right. Please state your name for the record, sir.
Leo Stringer.
Thank you, Your Honor. Today's the date and time for, 2 cases are set for sentencing and 2 cases are set for violation of probation. I have had the opportunity to review the alleged violations and the recommendations as to the violations of probation with Mr. Stringer. I guess I will start with those first, Your Honor, if Your Honor does not mind.
Go ahead.
We do acknowledge that there are the new criminal convictions and new pending criminal matters. And we do acknowledge that no proof of these things have been sent to probation. Mr. Stringer did indicate to me that he was going to try to get proof of Dawn Farm outpatient treatment. However, unfortunately, I have not received that yet to provide to probation or to the court. We are asking, as far as these cases go, if the court would consider not remanding Mr. Stringer. We do acknowledge that, yes, there are several violations alleged, and there's no getting around that. I'm just asking that the court, if you would consider not imposing the jail time. He does have some significant medical concerns he has been dealing with, and we are just asking if the court would consider not imposing the jail. And we do, as far as this 2 cases set for sentencing, Your Honor, I do not have any material changes to the PSI. As to the recommendation, my request would be similar. I would ask if the court would consider not imposing the jail time.
Stringer, anything you want to, Ms. Blair?
Yeah, sure, Honor. Teresa Clare on behalf of probation. Your Honor, I would just like to make the court aware. It already knows. Mr. Stringer has been on probation for over the last year on the 2 DOP cases. In those cases, he's done nothing. He's not paid 1 cent on either case or threat.
This statement from probation is devastating in a sentencing hearing. When probation officers say a defendant has done nothing, they're essentially telling the judge that the opportunity the court previously granted was completely ignored. Let's break down why this matters so much legally. Probation is not simply a lighter punishment. It's a conditional alternative to jail. The court gives someone freedom under strict requirements. Things like paying fines, attending treatment, avoiding new crimes, checking in with officers, and following supervision rules. If someone complies, probation works as intended, rehabilitation outside jail. But when probation reports show 0 payments, continued criminal activity, and ongoing non-compliance, the court begins to see probation as a failed experiment. As judges often interpret this pattern as evidence that the defendant either cannot or will not follow court orders. Notice another key detail probation mentions: new criminal cases and convictions. That's particularly damaging. Courts are usually willing to tolerate small probation missteps, missed appointments, delayed payments, but picking up new criminal charges during probation suggests the person hasn't changed behavior at all. So the probation officer's recommendation for jail isn't surprising here. Their job is partly to evaluate whether probation is still serving its purpose. And in this case, they're telling the judge it isn't working. Let me ask you something. If someone repeatedly violates probation conditions, should courts keep giving chances? Or is there a point where jail becomes unavoidable?
that is owed, that is high amounts, on both cases. The only thing that Mr. Stringa has done is picked up new criminal cases. He has convictions, he also has pending matters. I had conversations with Mr. Stringa about getting into treatment. Conversations go that he agrees. He's supposed to be getting his verification. He's doing these things. Probation never receives anything from Mr. Stringa. So those just go on, and he stays in non-compliance. Given his past behavior and his continued criminal behavior, probation is asking that the court follow the recommendation for a jail sentence.
Mr. Stringer, anything you want to say?
Yes, Your Honor. As far as my current situation, I've been in and out of the hospital like 32 times. University of Michigan Hospital has cited.
Now we finally hear directly from the defendant, and this is a critical moment in any courtroom hearing. When defendants speak during sentencing, they're trying to do something very specific, convince the judge they deserve mercy. Mr. Stringer is focusing heavily on his medical problems. Hospital visits, infections, serious health complications. These kinds of claims can influence sentencing because courts recognize that incarceration can be physically difficult for people with severe medical conditions. But here's where things become complicated. Judges don't just evaluate what someone says, they evaluate whether the story aligns with the evidence. And earlier in the hearing, we already heard the judge challenge part of this narrative. Remember when Judge Simpson mentioned tracking data showing the defendant had been out in public despite claiming he couldn't leave the house? That kind of contradiction can hurt credibility fast. Another interesting moment here is when Mr. Stringer mentions having a PhD and being a professor. That's a strategic move. Defendants sometimes emphasize education or career achievements to remind the court they're capable of living a productive life. The idea is to frame the situation as someone who lost their way temporarily, not someone who belongs in the criminal system.
I've supplied the court with multiple, documentations of my current medical situation. My knee's bleeding through my pants right now. I have osteomyelitis, my bone's infected in my leg. And I didn't.
In that regard, and I don't mean to interrupt you, but
Yeah.
in that regard, part of you haven't done any testing, you haven't done anything. Part of your reasoning behind that is basically saying you can't go out in public.
Right, Your Honor.
Well, we have your tracking, and you've been out in public. What were you doing at Briarwood yesterday?
I was trying to apply for a job online that I'm trying to do online. I had to go there and give them some paperwork.
Then why couldn't you go to community corrections?
I could, Your Honor. I don't have any money to pay for it.
Go ahead.
But I am so.
What you want to say?
But I do have a PhD from Michigan, and I am a professor. I was on FMLA from Eastern, but I'm slated to go back. Hopefully, I can do this in January 9th, so I'll be able to create an income. I have been sober. I tried to go to inpatient treatment. They wouldn't let me because of my skin condition, just to show the court that I was doing something. And I did send some paperwork with that. I don't know if you didn't get it, but
Not going to, no.
okay. Judge Barr's court got it, but yeah, I made a lot of bad choices earlier in my life. I mean, not earlier in my life, earlier with these cases, but I'm on the other side of it as far as me as a person and me continuing to try to do better. I made a mess of the cases, and I didn't know that I was still actually on probation in this case. And it wasn't even really brought to my attention that I wasn't in compliance until I spoke with Ms. Polera maybe 2 months ago. So I thought I might have had time served on this, but it was another case that it was time served on. But I would just like to for you to give me a chance that I can do probation, and that I can get through this and make myself a better person. I have so much going on medically right now too. I might, it's a lot. I don't want to get into it, but I'm at your mercy, Your Honor. I didn't, and this too, it's like, I didn't work so hard my whole life, and, get a PhD and do all these things in life to throw it all away. And I want the opportunity to try to do this. And if you give me this chance, I won't prove you wrong.
You were sentenced originally in July 24th of 2024.
This is the turning point of the hearing. Judges often reach a moment where they stop listening to explanations and start delivering their reasoning for the decision. And you can hear that shift clearly in Judge Simpson's tone here. He lays out the timeline. The defendant was sentenced in July 2024, and now more than a year later, the record shows no meaningful compliance with probation. In sentencing logic, timelines matter. Judges want to see steady improvement over time. Payments made, treatment started, violations corrected. When the timeline shows the opposite, the court begins to lose patience. Notice how the judge frames the issue. Not just violations, but continued criminal behavior. That's crucial. Probation is essentially a test of whether someone can function responsibly outside jail. If that test fails repeatedly, the judge is left with limited options. Another important courtroom dynamic here is credibility. Mr. Stringer argues he thought the case was time served and that he didn't realize probation was still active. But judges rarely accept that explanation unless there's clear evidence of a clerical mistake. In most cases, defendants sign paperwork outlining their probation conditions and are expected to understand them. At this point in the hearing, it becomes clear that the judge believes the probation opportunity has been exhausted.
Now here we are a year plus, almost a year and a half later, and you've done nothing except, as Ms. Blair indicates, just pick up new criminal charges.
I thought
I'm done.
I thought I was time served. I thought the case was over with, Your Honor. I really did. Until I spoke with Ms. Polaire 2 months ago, I didn't even know the case was still active. I made a mess, and I had like 4 or 5 retail frauds in Washtenaw County through different 14A, 14B, and 15th. I didn't know which one was which. And when I thought I had time served, I thought it was closed out because nobody told me anything different. And actually, I went to jail, was booked, and let go multiple times, and I never even had a warrant on this case. So I didn't even know that I wasn't in compliance. I didn't even know it existed.
You done?
Yes, sir.
So on the cases ending in 0962 and in 1452, since they have the same recommendation, I'll just do it once. On those, the probation cases, I'm going to revoke your probation. I'm going to sentence you to 365 days in jail, credit 82 days served, defendant to serve the balance.
And there it is, the ruling. Judge Simpson revokes probation and imposes a 365-day jail sentence, minus credit for time already served. This type of sentence is common when probation fails. Courts often impose the maximum allowed jail time for probation violations to reinforce the seriousness of ignoring court orders. But notice something interesting in the judge's decision. He also leaves the door open for inpatient treatment release. That's a key detail. It shows the judge isn't completely closing the door on rehabilitation. Instead, he's combining accountability with a possible treatment pathway. This approach is actually quite common in modern courts. Judges recognize that many probation violations involve substance abuse, mental health struggles, or unstable life situations. So rather than purely punishing the behavior, courts sometimes structure sentences that allow treatment if the defendant demonstrates commitment. However, the baseline message remains clear. Probation was the opportunity. Jail is the consequence of failing it.
I will waive the remaining terms, accept the financial obligations, discharge you from probation without improvement. I will consider release to Dawn Farm inpatient treatment on those cases.
Thank you, Your Honor.
On the other matters, on the case ending in 0616, $125 statutory fee, 365 days in jail, credit 41 served, defendant to serve the balance. I'll consider release to Dawn Farm inpatient treatment. And on the last case ending in 1677, I'll order $129 statutory fee. I will apply the bond in that case. I'll order 365 days in jail, credit 2 days on that case, defendant to serve the balance. I'll consider release to Dawn Farm inpatient treatment.
Your Honor,
Defendant is remanded.
Your Honor, may I say one thing? Just as far as the inpatient treatment, I have a misdemeanor warrant in another county, which I don't think they'll let me do. Is there any way I could do the Dawn Farms in jail program to get released that way?
This final plea from Mr. Stringer highlights something that often happens right after sentencing. Defendants try one last time to influence how the sentence is carried out. Here he's asking about treatment options, specifically whether he could participate in a treatment program connected to the jail system. That request suggests he's trying to turn the incarceration period into something that might still benefit his recovery or rehabilitation. But Judge Simpson's response is short and final. The sentence has already been pronounced. In court procedure, once a judge formally imposes a sentence, it's very difficult to modify it on the spot unless there's a clear legal reason. This moment also reveals how complicated criminal cases can become when multiple jurisdictions and warrants are involved. Mr. And Stringer mentions another warrant in another county, which can interfere with treatment placement or release options. These overlapping legal issues are extremely common in probation violation cases. Someone might be dealing with several courts, several warrants, and multiple conditions all at once, making the situation harder to untangle.
Is that feasible? Just because I know that you gave me bond conditions before to be released to treatment, and they wouldn't let me go because they said I had a misdemeanor warrant in another county. So I
You
just,
consider that at another time, but I pronounced my sentence. Defendant's remanded.
okay. Thank you, Your Honor. My coat.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Atkins. Mr. Atkins, state your name for the record, please.
Michael Atkins.
Your Honor, regarding the pretrial, I suppose I asked for an adjournment. We're still in negotiations, and then there's a bond issue we should address as well.
Yeah.
So Mr. Atkins had some missed tests and saw a positive test for alcohol. Regarding the missed tests, we have been in touch with the place that he's been testing at in Flint. It seems like there's a little bit of delay in getting those results here. For example, there was a test on the 31st that when we were here on the 5th was said it was missed. He did test on the 31st. That result is now on that report that was sent by Community Corrections. So we're trying to work out.
Is the alcohol?
Yes. So we're trying to work out the kinks on the delay on getting the test to Community Corrections. So that's the first piece. The second piece is the positive alcohol test. I've had multiple conversations with Mr. Atkins regarding the positive alcohol. I think today he would like to admit to the violation with a bit of an explanation. He is, I think Mr. Atkins' road to sobriety is a pretty long and interesting one. He was addicted to opiates. As of last year, he relapsed, but before that, he was clean for about 3 years. He was completed inpatient treatment. He was working as a counselor at a sober living house here in Ann Arbor. He was a sponsor. He had worked through the steps multiple times. So he's very familiar with substance abuse addiction and the struggles and journey that can take a person on. He obviously admitted that they relapsed last year. Again, he struggles with opiates, and he's been clean from opiates now for over a year. Is getting back into that sobriety journey. He is going to AA weekly, and has moved from Ann Arbor, where his primary problem was, to Flint, so he can. He's living with his brother, who's also 9 or 8 years sober, and re-enter that sober living lifestyle. So Mr. Atkins again admits to the violation. At the last court date, the court ordered him to come here to test in person. He did. The court ordered also for him to come in person today. He explained to me that his mom drove from Saginaw to Flint to pick him up and drop him off here. He's not trying to run from anything. He wants to take accountability for his actions, and I think he's doing that by admitting and trying to work through all of this. So I don't know if you want to say anything in addition to that, Mr. Atkins.
Your Honor, I take full responsibility of the positive alcohol test. I go to NA and AA meetings weekly in Flint. And I just want to not lose my job from incarceration so I can continue to, pay for what I need to pay for and so on and so forth.
He's willing to step up.
But has he taken the test? I mean, I got missed test and unable.
So
I don't have him testing.
there was an unable, I can't remember the dates off the top of my head.
November 12th.
Last week, he said he did go in the 13th and test to make up for that 12th. He did show me a PDF of those results, which were negative. It says on them that the sample was taken the 13th and it was received by the testing facility. The results were received by the testing facility on the 17th. And so he did test on that date. He did test on the 17th.
You're saying he did?
He did. I think here in community, maybe the difference is here, the results are done immediately at community corrections, from my understanding. It seems like at this testing location in Flint, they are sending the tests out. And that's how we get the sample taken on the 13th and the result coming in on the 17th. And that's delaying those results getting to community corrections, which is delaying the results getting to us. So I think that's part of the issue of the delayed or the missed tests that are reflected on our reports. But then, like I said, there was one that said he was missed on the 31st, and now we'd have a result for that test. So it shows that he did test, although it is a positive test.
Shelters.
Your Honor, based on the report, I trust defense counsel representations, of course, but based on the report that's before me that I'm looking at, in 1 month, we've had one compliant test, which was November the 7th, which was a test that the defendant had 2 days of notice for. The court recalls on November the 5th, when we were here, the court ordered him to test by Friday. So he had 2 days to go to that test. I believe the science, and what we're seeing here is a pattern of alcohol use.
Now the courtroom shifts to the second defendant in the hearing, Mr. Atkins, and the focus moves to substance testing compliance. This prosecutor's statement introduces an important concept in probation monitoring: behavior patterns. Courts rarely rely on a single positive test to determine violations. Instead, they look at the overall pattern: missed tests, delayed results, positive samples, and inconsistencies in reporting. And the prosecutor is painting a concerning picture here. A defendant previously found unconscious behind the wheel with drugs in his system, now showing signs of alcohol use and missed compliance tests during supervision. For judges, this raises a serious question about public safety. Driving under the influence cases carry heightened scrutiny because the risk isn't just to the defendant, it's to everyone on the road. What's interesting here is that the defense acknowledges the violation but frames it within the context of addiction recovery. That introduces a complex legal and moral question courts face all the time. Should relapse during recovery automatically result in incarceration, or should courts prioritize continued treatment? Different judges handle that balance differently.
And refusals or missed tests. If the court recalls the time of arraignment, I let the court know that this was an OWI second offense. The prior is from 2019, which is not that long ago. And the defendant was found passed out behind the wheel of his vehicle, had to have 2 doses of Narcan to even come around at all, and was discovered to have 47 nanograms of cocaine in his blood. I'm extremely concerned for public safety. I think it's great that he's moved in with his brother, but clearly that's not working because he's been residing there since the pendency of this case, if I recall correctly. And we're having these tests that are showing ETG. We had 1 for THC, and we're seeing non-compliance. The concern of the people at this time is public safety. And I'd ask the court at this moment, remand him for the bond violation. If the court is inclined to release them, I would request a scram tether, as well as the continued intensive supervision for drugs. That's also an issue here.
Anything else?
Anything else?
No, ma'am.
So here's part of the problem as I'm seeing it. And yes, I'm concerned about public safety, but I'm also concerned about this defendant. The thing is, you know what it takes to get yourself sober. And I'll just put it in a colloquial sense that what you're doing right now is you're just half step. And you know that. You know that you are not doing what it takes to get yourself there. And that's why things are coming out and working this way for you. You got to make up your mind, young man. If you want to do it, you know how to do it. You've done it. You just have to do it. This half process for you is not going to work. And you got to figure that out. But if you think that what I'm going to do while you're in the process of trying to figure that out is allow you to be out there, be in a position where you decide to get behind the wheel because you're doing whatever and then end up killing somebody, that's not going to happen. So what I'm going to do is I'm going to adjourn this to December 3rd, 2025, 9 a.m. He figure out in that time what he wants to do. But at this time, his bond is revoked. Defendant.
Judge Simpson ultimately decides to revoke the bond and adjourn the case, giving the defendant time, but also placing him into custody in the meantime. This decision reflects the court trying to balance two competing priorities: public safety and rehabilitation. On one hand, the judge clearly recognizes that the defendant understands recovery programs and has previously succeeded in sobriety. On the other hand, the testing records and missed compliance requirements suggest that the current recovery effort may not be fully committed yet. By revoking bond, the court prevents the risk of further violations, particularly the possibility of driving under the influence again. But by setting a future court date rather than issuing an immediate final punishment, the judge leaves space for the defendant to demonstrate a real change in behavior. And that's one of the broader lessons from hearings like this. Courts are constantly walking a tightrope between accountability and second chances. Some defendants truly turn their lives around after moments like this. Others, unfortunately, continue down the same path. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.